We'll intervene whenever we decide it's in our national security interest to intervene. And if you don't like it, lump it.
The problem with America is not that we go around marauding around the world imposing ourselves. The problem with America in the last 10, 15 years, since the end of the Cold War, really in the last 60 years, is that we've been too slow to get involved.
I don't know how many Iraqi civilians were killed, but I can assure you that the number is the absolute minimal that it's possible in modern warfare.
Every nation in every region now has a decision to make. Either you are with us or you are with the terrorists.
You know, that land over there is yours. You'll go back to it one day because your fight will prevail and you'll have your homes and your mosques back again because your cause is right and God is on your side.
Welcome to the Darkened Hour.
Welcome to another episode of the Darkened Hour. I'm your host, Adam Fitzgerald. With me today, my co-host is Richard Cox. Richard, good afternoon, sir.
Good afternoon, Adam. Good afternoon.
And with us today is a very special guest, just like Al Capradan. Richard Kammen is a criminal defense lawyer with his office in Indianapolis, Indiana. He concentrates his practice in serious felonies, white-collar defense, complex crimes, and death penalty defense. He is of counsel to the law firm of Kammen and Moudy. He has defended over 300 homicide cases, including approximately 40 death penalty cases in both state and federal courts. No client that Mr. Kammen has represented at trial has ever been sentenced to death. In October of 2017, Mr. Kammen served as lead counsel in the United States versus Abdul Rahim Al-Nashiri, who was charged before a military commission at Guantanamo Bay, Cuba. Al-Nashiri is alleged to have been a central figure in the bombing of the U.S.S. in the year 2000 in the port of Aden, Yemen. He is also the recipient of the Pro Bono Award given by the Indiana Bar Association and a Lifetime Achievement Award from the Indiana Public Defense Council. Richard is also the author of two books, one in which we will speak at some length today, Torture Justice, Guantanamo Bay, and of course, as usual, the link to purchase the book will be in the description. Mr. Kammen, thank you very much for coming on.
It's my honor to be here.
Well, I like to start off simple usually, and in that the book is uniquely written, that it isn't fiction, but the names certainly are to protect the identities, I guess, for any legal damage. Is that the reason why you wrote it this way?
Well, actually, after I left the Nashiri case, I thought about writing a nonfiction book. And, you know, it would have been, okay, I was a lawyer. I was involved in this big case. The government was mean. They did some outlandish things. I quit. I was required to quit for ethical reasons. And there was really no market for the book. My agent said, well, you know, there's just no interest. And when I took a step back, that made a lot of sense. The case is still going on. You know, lawyers leave cases all the time. And so I played around with and started writing the story as fiction. And I found two things. First, it was easier to tell parts of the story as fiction because I didn't have to worry about attorney-client privilege. I didn't have to worry about confidences with members of the defense team. And I didn't have to worry as much about classification issues. The other thing was there haven't been any trials in Guantanamo, or not any of the major trials. And so I was able to write about what I think a trial will look like, if there are any trials, and also some of the intrigues that exist, that do exist and are likely to exist if there are trials, such as unlawful command influence and that sort of thing. And so for a whole host of reasons, I found that writing it as fiction really became a much better vehicle to tell what I think is the story of Guantanamo, at least from the perspective of what I think cases there have looked like and will look like. Now, certainly some of it at the beginning, it does take events that did happen and either enlarges them or makes them smaller. I mean, again, it is fiction. But on balance, it really is about being able to tell the story as forthrightly as possible.
Correct. And this is the way I love the way the book was written. And like I said, I read it in basically 5-6 days. In that, you don't lose the reader with the fiction that you have. You basically told it in a way that it is carefully written. And for those who are confused about certain names, it's not confusing at all. In fact, when you put 2 and 2 together, you find out exactly who these people are and what they're talking about.
Well, but I want to say one thing.
Sure.
There are 2 characters, especially the character of the Chief Defense Counsel, and to a lesser extent, the character of a reporter. Those are somewhat different. I mean, the Chief Defense Counsel I worked mainly with, General John Baker. He was fabulous. He was absolutely a stand-up, do anything for his people, and completely different than the person described in the book, who is completely fictional. Similarly, the reporter, I mean, there is a reporter, Carol Rosenberg, who has covered Guantanamo. Clearly, the reporter in the book is somewhat modeled after her. But again, for artistic reasons and to just make a better story, I've changed her somewhat. So I really want to be clear about that,
Sure.
I have changed some of the characters completely from people that might be identified, real people, and especially John and Carol.
Usually with any interview, I'd love to get personal to show the public that there's a, not just a part-time story right here. You're a unique person. And so you actually graduated from New York University of Law and then went on to enlist and then became a public defender at the Marion County Court.
Right.
But who were the primary influences in regarding for you to become involved with the judicial system so early?
That's a very, very good question. From the time I was certainly young, 15, 16, I think like most lawyers, my father was a doctor, but like most lawyers, I really wasn't very strong in math. And so I sort of had the sense that medical school wasn't in my future. My father had a patient, a lawyer in Indianapolis by the name of Forrest Bowman, who was quite prominent at the time. He was certainly an influence, and in fact, he was my first employer, and was very much one of my mentors. But I always had the notion of standing up for people in court is what lawyers are supposed to do. And so really, from the time I began law school, going into criminal defense was my goal. And I was fortunate that I was good at it. I enjoyed it. I liked, the rough and tumble of it. It's certainly not for everybody. So I would say that just general life, sort of maybe being exposed to things I wasn't even conscious of. And then Forrest were the main drivers of the beginning of my career.
You defended over 300 homicide cases, including approximately 40 death penalty cases. in both the state and federal courts. This vast amount of experience would have later perfectly served you to become involved at Guantanamo Bay. And is that not true?
Yeah. I mean, I was recruited by the American Civil Liberties Union when they started the John Adams Project in 2007. They were looking for lawyers who had a lot of federal death penalty experience, who were willing to travel and get involved in Guantanamo. And so I was fortunate that I was one of the 6 people they originally contacted. And, I was very much honored to do that. And it's, the involvement in Guantanamo was certainly one of the highlights of my career.
Can I just interject and ask, was there an ethical dimension to you defending death penalty cases? And Adam said earlier that you never had anyone executed who you defended. So was that an influence on why you pursued that kind of law, particularly?
No, in the late 70s and early 80s, the death penalty was new to the states. And at the beginning, none of us really knew what we were doing. But as things evolved, there was one of the early cases in Indiana I was asked to become involved in, and because of the way Indiana law worked, I was able to be appointed. And in a way, I saw that as kind of the natural progression. Those were, I think, good lawyers want to do big cases. And I enjoyed, one of the advantages of death penalty cases is that you work with a team. Generally, especially in the early days, lawyers were one-man bands. We would, I would be appointed on a case or hired on a case, and, maybe I'd have a law clerk helping me, but, basically I was doing most of the work. And in a death penalty case, you had, by statute in Indiana, and the way it's supposed to work, at least 2 lawyers. You'd have a mitigation specialist, and in that first case, we had a jury consultant and an investigator. So working with the team really became something I enjoyed. And in many respects, it spread the responsibility. But so I think in that sense, it was a natural progression. And the other part of it that I enjoyed in doing serious criminal cases, ideally, you really understand your client's life or how your client became involved in this particular situation. In death penalty cases, you had to understand your client's life. And I found that to be very interesting and generally very, very rewarding. Because very often the difference between the client and just a good person who goes through their life without ever getting in any trouble is the fortune of birth or the fortune of having parents who could nurture him or her. And so it was really a very rewarding to understand what I describe as how the person went from being a baby in his mother's arms to the person sitting in the courtroom charged with, in many cases, a really horrible event.
After the attacks of September 11th, the Bush administration actually, along with its CIA and White House legal counsel, took steps to ensure that the civil liberties of foreign combatants were compromised. Were you surprised at the obviously illegal steps the lawyers were taking here, sidestepping the Geneva Conventions as well as the Constitution?
Well, from the outside, I was disappointed. I mean, when we kind of realized what was happening, it was really, really disappointing. When I became involved and learned the details, it was on one level disappointing, on another level horrifying. And the other side of that, and it's mainly in the military side of the lawyers who sacrificed a great deal and stood up to Bush and Addington and Cheney. And, a lot of those early military lawyers sacrificed their careers to do the right thing. And so on the one hand, you had lawyers who were willing to look the other way and really shape the system and shape is not the right word, really distort the system to approve torture. And then you had a group of lawyers who were heroes who stood up and said, we're not going to let this happen. And to a large extent, those people haven't been appropriately recognized. And in my book, I sort of dedicate the book to the people, the lawyers from the military commission's defense, because they are, in my view, especially all of the military lawyers are really heroes. They a lot of them sacrifice their careers to do the right thing.
So let's go right into the book, shall we? In chapter
Sure.
1 of your book, you start up the chapter with an individual by the name of Hussein al-Yemeni, who is allegedly the mastermind of an al-Qaeda attack on the U.S. Air Base in Kuwait. And Connor Mendelsohn took the case.
Right.
Was there any reservations about taking it head on, knowing that this case was a very huge case?
Are you asking me or Connor Mendelsohn?
Connor Mendelsohn.
No, because Connor Mendelsohn is ambitious to a fault. And as he describes it, he's ambitious. He's likes the notoriety. And, the ACLU said, okay, we want the best of the best of the best. And as he says, I didn't realize that what they really wanted is someone egotistical and dim, and so dim that they wouldn't understand the tar pit that they were getting into. And so he says, well, when it comes to egotistical and dim, that's me. So he had no reservations at all.
He seemed, in the book, Hussein seemed rather hesitant about Mendelsohn being Jewish. He couldn't wrap his head around the fact that Connor only saw this as a legal case and not a persecution against his Islamic faith. What was this like for Connor? And how did Connor manage to keep him concentrated on the issue of innocence or guilt?
Well, again, in the book, Mendelsohn is quite angry about the fact. I mean, what happens is that the client learns he's Jewish, has some reservations about that. They thought they had them resolved, and then he raises it with the judge and says, I don't know that I can have this fellow represent me. And Mendelsohn's angry about that. It's like, well, okay, I'm done with it. And, that is my experience as a lawyer is that when there are times clients raise questions about lawyers, how can I trust you? You're paid by the state. How you're a public defender. How can I really trust you to fight for me? And of course, one of the responsibilities is to overcome that reluctance. And that takes skill and patience and willingness. But there are times when the client I'm in Mexico, so you might hear the occasional firecracker or dog barking. There might be times when the client just simply doesn't get it. And no lawyer wants to be fired or, essentially be called out for things that he can't control. And so, and Mendelsohn is angry about that. Essentially, the client relents and makes him promise he'll do his best. And of course, when a client says, "Oh, Mr. Kammen, will you promise to do your best?" On one level, that's easy. Sure, of course. On another level, it's like, it's insulting. I mean, but the goal is to foster the relationship with the client. And so, sometimes lawyers have to swallow their pride and jump through the hoops. That's what happens with Mendelsohn. But of course, also in the book, the interpreter is the bridge, because the interpreter essentially says to the client, "Look, and all in Arabic, you can trust this guy." And that, hearing it in his own language, minimize, or at least helps to begin to bridge this gap. And so what I tried to describe in the book, and I'll be candid, this is, in this sense, similar to my experiences with Al-Nashiri, is a client who starts from the position of, "Why the hell are you people here? I can't trust you. I don't want anything to do with you," to, in the end, "Please don't leave. I care for you. I love you." And I would say that, and this is not classified, I mean, certainly with the whole team, not just me, Nashiri in the Cole case was very untrustworthy at the beginning, untrusting at the beginning. He had every reason not to trust Americans. I mean, he had spent 4 years being destroyed by the CIA. And then a group of Americans show up, and some in uniform, "Hi, we're here to help you." And he's got no reason to trust us. But then to the end, when I left, we were very close, and I know he has remained close. I mean, I get messages occasionally through the current lawyers from him. I know that he is close with his current lawyers. But that was an effort of years getting, that change. And so in the book, I tried to describe that journey for the client and the lawyers of, I'll say, mutual distrust to genuine caring at the end.
Just to follow up on that, there's a very interesting tidbit I saw in chapter 8 where Hussein mentions that what it was like to be at a CIA black site, using Connor and his staff to enact what they did to him. Can you brief us more about what you've written here and why they had to go through this route to begin with?
Yeah. There's a technique that I learned through an organization called the Trial Lawyers College. And the Trial Lawyers College is a training vehicle for plaintiffs' lawyers and criminal defense lawyers. And the starting point is using what we call psychodramatic techniques to both to discover the truth of events. And psychodrama is basically discovering the truth of events by putting them in action. It's something I use in almost every case. In the book, of course, the character in the book, Al Yemeni, like the people who were in CIA custody, were all very, very damaged people. Nashiri, Al-Baluchi, KSM, all the people who were in CIA custody are been hugely damaged by what the United States did to them. And so you couldn't say, I mean, we learned it. It was a learning process for us. You couldn't just say to somebody, tell us what they did to you. Because as other lawyers have probably told you, the truth is they don't know. It was all a blur. And also it's too painful. It's actually very difficult for somebody who has been tortured to talk about what was done to them. Psychologically, you can understand that. Well, one of the things that psychodrama can do is remove the person from the event. And so as we describe it in the book, and as I said, I've used this in many, many cases, essentially Mendelsohn says to his client, okay, you just sit off the side. You are what we'll call the director. Now, you pick somebody to be you, and then you tell us how to be, what position to be in, how things should unfold. And I mean, this is, I can say this, on the times, and I can't get into the details, but on the times we did this with Nashiri, two things happened, and I describe this in the book fictionally. First, it was with some of those that we began to understand how brutal what the United States did. It's one thing to talk about walling, slamming a person's head, It's another thing to see it, or to feel it, or to be blindfolded and have somebody hit you and wrap a towel around your neck and slam you against a wall, or put you in a stress position. And again, it's easy to say, okay, people are put in stress positions, and they may even describe it. But when you're actually in it, or you see somebody 2 feet away in it, and you see how painful that is, it changes everything. And so for us, it very much helped us begin to understand how obscenely brutal what the United States did to those people, because it took it out of an intellectual exercise and made it emotional. And I think for clients, and I think for Nashiri, when he saw how upset we were, I think it changed it for him. Because then all of a sudden he had a sense that we cared. And in the book, El Yemeni has a sense when he sees people crying and then, somebody throwing up because they're so horrified. He has a sense, and he says, come back tomorrow. We have much to talk about. And again, using these, one of the difficulties for all the lawyers is, how do you deal with somebody who still is feeling the effects of torture? I mean, here we're 20 years later, and I know this is other lawyers you've interviewed, and the government hasn't given these people any meaningful treatment. In many respects, what the government is doing exacerbates the pain. And so here they are 20 some years later, still laboring under the trauma. And yet the lawyers who they need to have a trusting relationship with, have to figure out the ways of bridging that gap. And I was fortunate that through the training I'd had, we were able to do that. And that's one of the reasons I described that in the book, because it was, in truth, an important scene.
The book really gives us a glimpse of the insanity that happens inside Guantanamo, but it also talks about the insanity on its external structure. And what do I mean is that there's this point about driving to the courtroom access point where Connor had to drive through a barrage of checkpoints and barriers, which seemed like almost like a maze, which were inside, and it was a maze. And every single guard that was there would ask the same questions, go through the same rule sets, and then you had to go to another maze and do another structure. Can you explain to us how Connor viewed these experiences of visiting defendants and encountering the checkpoints at Guantanamo Bay Prison?
Well, I'm sure he viewed it like any lawyer who was there, that this is, this is security theater. If you go to court in the Southern District of New York, or Washington, D.C., or Indianapolis, or any federal court, and you're involved in a capital case, I mean, those are big cases, and those are cases where there has often been a lot of violence and occasionally threats of violence. And yet, basically all that happens is you go through a metal detector. Maybe somebody will, sort of leaf through a briefcase to make sure there's no guns. They'll take your cell phone away or make you put your cell phone in a room or something. But it's not really that much different than going through airport security. Of course, if you think about Guantanamo, you just can't go to Guantanamo. I mean, you have to jump through all kinds of hoops to even be at the base. You have to have all kinds of clearances to get into the area of the base, much less the area of the courtroom. And yet, because they treat it like it's a theater of war, they have all this mazes and cones and stuff. But I think this is my opinion, I think it's because it's so overstaffed that they just need to give people stuff to do. I mean, if I go into federal court in the Southern District of New York, maybe there's 2 guards at the X-ray machine. Maybe there's 3. Well, in Guantanamo, there may be multiples. There may be 10, 12, and they've got to do something. So, okay, they have a checkpoint here and a checkpoint there. And so again, Mendelssohn's response and one of the other lawyers' response was, well, okay, this is a security theater. And, I mean, that's certainly what it was. And that's how Mendelssohn saw it. And that's how his team saw it. And I think to a certain extent, they appreciated the ridiculousness of it, or they just sort of, it's like there's a scene where, okay, they've gotten through this, they're ready to go to court. And a guard says, well, you can't take the notebooks in because those could be a weapon. Yeah. I mean, true story. I'll back up. True story. Typically, what I would do in a case is I would have a spiral notebook, one of those big, thick spiral notebooks you buy at Target. And I would keep all my notes in there. And so they would all be in one place. Well, to a certain extent, you'd have to give up your notes, and they would be classified. So you'd rip them out, but still have the spiral notebook. Well, one time we showed up to visit, and the guard says, well, you can't take your spiral notebook in. Well, why not? Well, the client might use it as a garrote. He might take the spiral out and use it as a garrote. And, the response was, he's chained up. He's got not very much range of motion. If I'm going to be threatened, I can take 6 steps back and I'm safe. There's 3 or 4 other lawyers here. You guys claim you're not listening, but you're watching on video. So if all of a sudden you see him trying to unravel the notebook, oh no, this was the rule. And we ended up having an evidentiary hearing about this, where the commander of the prison was adamant that this could not, spiral notebooks could not be taken in to see the client. And, at some point, I said, okay, here's a spiral notebook. Take the thing out. Show us how it could be done. Well, after he sat there for about 5 minutes fumbling around, the judge just said, okay, I've seen enough. And that was the end of that. But that's the kind of silly stuff that happened in the real world. And again, I tried to describe in the book some of it.
You talk about security theater. I look at pictures on the internet about Guantanamo, and I see these defendants in orange uniforms, malnourished, not getting proper meals, surrounded by 5, exceptionally big, large men with guns. And you would think, how could there possibly be any threat? And where would they go anyway? I mean, they're all surrounded, by ocean. And it just seems that it is security theater. There's a great quote in the book, and I loved it so much, where it says, Guantanamo, a pointless maze leading nowhere, accomplishing nothing, all at an extraordinary cost. And I said, that is exactly the perfect description of Guantanamo. Would that not fit well?
Yeah. Thank you. I mean, that is Guantanamo. And I think current events are proving that. I mean, they're trying to work out a plea in the 9/11 case, and then all of a sudden the Secretary of Defense blows it up. To what point? I mean, they're 25 years since 9/11. And here, and they're still not close to a resolution.
Yeah, that's a question I have for you later. I want to expand your thoughts on it. But incidentally enough, I just thought of something, Mr. Kamen, regarding the U.S.S. Cole. None of this would have happened had an original plot materialized, and that came from the Millennium Bomb plot, in which there was multifaceted instances within the plot. One of them was the bombing of the U.S.S. Sullivans, in which a boat driven by martyrdom Arab terrorists sank because there was so many weapons on the boat that they just basically sank. Had that operation been carried out, you probably would not have been writing this book, and Connor Mendelsohn would not have been defending Al Hussein. Or in that case, you basically would not have defended Al-Nashiri, and none of this would have materialized had that operation had been successful. What are your thoughts about that much?
Well, if you're asking me about the Sullivan's case, I mean, again, that's, there's this notion that Al-Qaeda was this, wonderfully well-organized, well-oiled machine. And I think in many respects, they just got lucky. Now, again, the coal bombing couldn't have happened without the government of Yemen.
Right.
So they got lucky. Plus, they were had a lot of outside assistance from the government. The Sullivans, you described it. They were thinking about attacking, according to the unclassified documents, attacking the Sullivans. A boat was loaded with explosives. They didn't know what they were doing. It was overloaded. The boat sank. And then what do? The boat is sunk. We've got these explosives. There's this whole kind of Keystone Cops. I must have looked like trying to, what do we do now? I don't know. I don't know where I have heard this. And so it may be things you've published. It may be things I've just heard, maybe things I've read, but somewhere along the line, I have this sense that after the 9/11 attack, the overwhelming response in Al-Qaeda was basically, wow, that really worked. I mean, almost complete surprise that they got away with it. And that doesn't minimize the horror of it. And I'm not trying to make fun of it because it is such a dreadful thing. But again, to a certain extent, as we know, in many respects, the government had warnings, but didn't connect the dots in ways that allowed that attack to happen. And I'm going to tread lightly because I don't recall if this is classified or not. I think that there is similar failure to connect the dots with respect to the coal attack. And so I think to a large extent, if the Twin Towers attack was the product of arrogance, they'll never get through. They'd never, who would think of hijacking a plane, that sort of thing. I think maybe to a lesser degree, there was a failure to connect the dots with respect to the coal attack as well, because I think that there I think they had ample warning. I think that they had reason to know to be afraid, and things just weren't communicated in properly, and maybe the threat of the risk wasn't communicated properly. And I probably
No, I was just going to say.
I want to tread softly because
No, you're fine by us. No, and actually, you're not off the reservoir here because I have written extensively about pre-intelligence involving with 9/11. There was enough out there regarding airline security, which was being threatened with the Pachinko plot in 1996. And not just with 9/11 itself, also the embassy bombings as well. There's a story about an Egyptian who was involved with the plot, basically went to a U.S. embassy, warned them about a threat to U.S. embassies and the security lapses. They ignored those warnings in the months prior. The ambassador to Nairobi to the United States warned about security lapses in the building when the United States went to check and basically ignored them and whatnot. There was a lot of threats out there, and especially with the U.S.S. coal, there was enough information out there that could have basically beefed up security at the very least. So you're not off the reservoir there. Interesting you talk about the threats of the dangers of dealing with the Yemeni government and the Yemeni authorities. There's a fantastic part in chapter 13 where Connor is brought before, he's actually trying to find the Hussein family, and was hard. It was going through the dangers of what Al Qaeda could do in Yemen. They could capture you and hold you for ransom. But Connor actually says the risk is worth it. We could try and find his family. And as he's traveling there, he finds it quite a challenge and needs the help from a guy named Nabil to help with the travel. And shortly afterwards, Connor meets with the Hussein family, and then from there meets with the actual Yemeni family in Mecca. And both times, Connor had to go through a lot of hoops and also go through a lot of danger to meeting both people in Yemen and Saudi Arabia. Could you explain a little bit more how about the fears, were they warranted for Connor?
Well, I think the reality is that when people, well, let me just say start like this. One of the obligations of a death penalty defense is to understand the client's life, and you can't understand his or her life without understanding their family. And so meeting with the family and meeting with the family extensively is one of the obligations of death penalty defense. And I know lawyers who've gone to Colombia, El Salvador, Yemen, the Philippines, but we're not talking necessarily the capital of these places. We may be talking, Mexico. We may be talking, using Mexico as an example, areas where there's a huge cartel presence. And so it's been my experience that very often lawyers, I need to go to Mexico to find my client's family. Okay, so you jump through the hoops, you go to Mexico, you find somebody who can help you, and you find the client's family. And I think very often we don't see or have any sense of danger until it's all over. Until, you sit back and think, well, that could have really broken bad. And so I think for Mendelsohn, he was very much, this was part of the job. And this was the best way to do it. And I think it was only after sort of they get back to Sana'a and, they've sort of pieced it all together that they realized, wow, this could have really broken bad. I mean, Yemen is like Mexico. Mexico's, Yemen is, once you get out of Sana'a or Aden, Yemen's the Wild West. And especially in the tribal areas, Yemen is really the Wild West. Just like El Salvador can be, or Guatemala or Mexico in some places. And so, I think he did not appreciate essentially as it was going on. It was just, you put your head down, you do the work. And I think that's pretty realistic of what lawyers do. And certainly we went to Yemen. I went to Yemen twice. Other members of the team went at least one or two more times. And, the first time we went to Yemen, it was pretty stable. 6 or 9 months later, it had a feeling it was really going to deteriorate. And then a year or two later, maybe a little longer, when he had people go there, the government really didn't want them to leave the embassy because they felt it was too dangerous. So, but you know, I don't think anyone has the sense of, oh my God, this this is really risky, so I'm going to do it anyway. I think it's like, well, okay, this is part of the job, and the risk seems that whatever risk there is acceptable. I mean, my own practice, for example, I had a client who was an LA gang guy from South Central. And I would go to visit his family, and another lawyer and I went to visit with his sister, who was living in the projects. And so, we probably got there at 1 or 2 in the afternoon, and we were spending time with her, and it was getting to be about 4 or 5. It was dark. She says, well, you need to leave. And, well, we're not done yet. She says, well, you can come back tomorrow. You can come back the next day, but you do not want to be in this neighborhood after dark.
Mm.
Well, why not? Well, 2 white guys in this neighborhood after dark, you don't want to be here, trust me. And literally, she walked us to the car, and, people were staring. She says, it's okay. It's my brother's lawyers. So, there can be danger in any of these situations.
Richard, do you have any follow-up questions?
No, I'm good at the minute, thanks. This is in line with what I was going to go down. So you carry on there.
So, Mr. Kammen, we've only gotten what the government says about Al-Nashiri, but you knew the man to an extent, to a very large extent almost. So in your detailed and honest assessment of Abdul Rahim Al-Nashiri, what was he like to you?
Well, like I said earlier at the beginning, he was very, very distrustful, but that was largely because he was very damaged. And so I would say if we met with him for 4 hours, in terms of actually learning something new, it would be very, very limited. But again, over time, it morphed where I think we became close. With any criminal defendant, there's always going to be boundaries. There has to be. I mean, at the end of the day, you have responsibilities to them, absolutely. You also have responsibilities to the court and to your team and, doing things correctly. So there's always going to be boundaries. But certainly within those boundaries, we became very close. I mean, one of the tests I use in representing people, just sort of the Kammen test is, okay, if they were released, would I let him stay in my home? And I've had clients that the answer would be absolutely not. I really like him. He's, I wish the best for him. Would I feel comfortable with him in my home that he, would I probably wouldn't. Al-Nashiri, absolutely. If he were somehow released and ended up in the United States and needed a place to stay, absolutely. But what people don't, there's two or three things people don't realize. If he went into U.S. custody when he was 25. That is, well, he was probably 35 because as best we knew, I mean, my guess is now he's around 60.
Hmm.
I mean, so all of these 9/11 guys, Al-Nashiri, I mean, they're all basically old, damaged men. And so, you know, would I feel personally at risk from Al-Nashiri? Absolutely not. Did I like him? Absolutely. Could he be funny? Absolutely. Could he be charming? Sometimes could, but he was also could be very damaged. And so, you know, you learn to deal with people and recognize that, you know, sometimes lawyers have bad days, sometimes clients had bad days. And given some of the circumstances at Guantanamo, it was a wonder that there weren't more bad days, because a lot of what happens there is very peculiar and not like what you would see in any other jail or prison I've been associated with.
You know, before we hit the recording, we were talking about the recent deal that was made by the U.S. government and the 9/11 defendants that was rejected the very next day by Defense Secretary Lloyd Austin. In your opinion, will we ever see a trial for the U.S.S. call in 9/11?
You may see what will look like to the untrained eye as something that resembles a trial. But to anyone who knows anything about the American legal system, it will be a sham. For example, in the Cole case, most of the evidence that was generated by the FBI was generated, as I said earlier, under the thumb of the Yemeni Political Security Office. The FBI could only interview the people they wanted. The Yemenis would let them interview. In some cases, they were limited in what questions they could ask. And so the evidence and you know, and the people, when they were interviewed, were often in Yemeni custody, and nobody really knows the circumstances of their confinement. And so, you know, the trial might be an FBI agent in 2026 or 7 saying, well, I've got this report from an FBI agent that was written in 2002, in which he interviewed this fella from Yemen who, I don't know what he, you know, who was under the control of the Yemeni government. And here's what this report says. I mean, it's basically hearsay upon hearsay upon hearsay. And so actually having somebody come into court and say, wow, I saw him do this, I saw him do that, I saw him do this other thing. I mean, that evidence isn't there. Now, could have been there maybe in 2003, maybe, who knows? So, but to give you an example of the problems, Al-Nashiri was interviewed by the FBI under the so-called clean team, which we now know was really just an offshoot of the CIA. And that statement has been suppressed. That is on appeal to the Court of Military Commission's review. Maybe that'll get decided this year. Maybe that'll get decided next year. I've heard stories that they're waiting. There's a similar motion in the 9/11 case. You know, the court wants to see how that turns out. Well, if that case is, if that confession remains suppressed, presumably the government will take another appeal to the DC Circuit and then perhaps to the U.S. Supreme Court. So you could be talking about 2 more years, that litigation. You know, in 2027, if the confession remains suppressed and the government then decides to go ahead with the trial, what does the trial look like? I mean, you know, we've got a bunch of hearsay and, oh yeah, this guy was tortured. So it won't look like anything resembling a real trial. And that's, again, one of the things I tried to do in the book, was to show kind of how ridiculous a trial under these circumstances will be. I mean, here's another example. The jurors are military officers who are brought from all over the world to Guantanamo. Well, okay, if I'm doing a case in, again, Indianapolis, the jurors might be, you know, they're sort of randomly selected from the Southern District of Indiana. They come to court. You know, they maybe have read in the newspaper, you know, the Jones case is going to trial. So they figure, okay, I guess I may be a juror on the Jones case. But as a rule, they have no particular knowledge other than maybe a little bit of what they've read in the paper, and no particular stake in it. The military officers will know that they're being subpoenaed for the 9/11 case or the Nashiri case. They will know that these are senior military officers. They will know that somebody higher up is grading their paper. Certainly we saw military cases when Trump was president, in which he made statements essentially saying, I would expect the jury to do this and such. And I describe a scene in the book where the president basically says, we're paying close attention to this trial, and we would certainly expect this jury to return a death sentence. The jurors, the military jurors, know their papers being graded. And you can say, well, that's, you know, and to a large extent, military jurors are good jurors. I mean, I've tried several court-martial cases, but this is different. And you don't know to what extent this will disrupt the proceedings. So the notion of, you know, sort of randomly selected people drawn from the community, I mean, it's just not going to be like that. You know, the notion of everything sort of proceeding smoothly won't be like that. You know, the trials could take months, and, you know, do people go home? Do they go on, you know, do they get breaks? I mean, it's all going to be a mess. And, you know, having been involved in a number of it all to Guantanamo, where these difficult living conditions, kind of a hothouse where, you know, everyone's kind of close to each other, and you know, it'll be it'll be interesting. But like I say, it's a long way of saying, I just don't see that. I don't believe it will look like anything people will recognize as what an American trial should look like.
Final question, Mr. Kammen. Why is it important for people to read this book?
You know, Guantanamo's kind of been lost to the public. You pay enough attention. You've worked with this. It's not uncommon for people to say, wow, I didn't know that was still open. Or for people to say, I can't understand why these cases are going on. What I've tried to do is describe essentially how much torture taints the system, taints everybody who is involved, taints the prosecutors, it taints the defense lawyers, it taints the clients, it taints everything. And that's very much true in Guantanamo. I've also tried to describe, as you describe it, sort of the insanity of it all. And one of the best compliments I've received about the book was from several lawyers who were there, who says, man, you captured it. You captured sort of how crazy it all is. You know, all of this, I mean, we see this. People were somewhat, on some level, glad or outraged that there was an effort to settle the 9/11 case, to give everyone involved, especially the survivors, some closure. And yet now that's been undone. The Cole families certainly want closure. And here it is over 20 years later, and they're no closer. They may be further away now than they were 10 years ago. And so my hope is that if people understand what this is really like, you know, it'll become less political, and essentially everyone will say, okay, we need to be done with this. We need to do what is necessary to end this. Because it's just kind of a canker on the sore of American justice. The fact that you've got these cases terribly compromised by torture. And, you know, everyone wants to pretend we can somehow make this work. And that's, you know, you got 4 flat tires, the car ain't going to run. So ideally, people take that away from the book. Plus, hopefully, they think it's a good read.
Richard Kamen, learned counsel for Abdul Rahim Al-Nashiri, and also the author, Torture, Justice, Guantanamo Bay. Thank you very much for coming on.
Thank you very much for having me. I really enjoyed it.